example, you may recall this. The committee discussed this point, and Senator Bohowski pointed me in the direction of where that data you're looking at now. That's so that lines 19 to 21 on page 1. You remember the committee talked about wanting to find some more recent updated data, and rather than using that 2016 Rand Corporation data that was in the House version, this uses some Vermont Department of Health version that was updated just this year in January 2023, and providing that 44% of Vermont households.
Peggy, someone just texted me and said there's no audio on the live stream.
I just fixed it.
Okay.
Yeah.
Go ahead, Ed.
Yes, no problem. Then you have a couple of deletions from the findings on page 2, number 7, the one about which persons are at greatest risk of suicide. The sentence in subdivision 8, lines 11 to 13, also about.
Well, I didn't know what that, I mean, we don't know, and we're putting in the findings if we don't know something. Usually we don't do that.
Yes, so it uses that phrase "are known to have," which carries some ambiguity.
It's a nice way of saying we don't know, but maybe.
The finding about straw purchases on page 3 is also deleted. I think the committee's thought was that was addressed in S4.
Yeah.
Page 4, this change to the purpose on lines 3 and 4 is actually was proposed by the Attorney General's office when the Attorney General not only testified, but followed up her testimony with some written proposals that were consistent with the testimony, just put them in writing so we can see what they were. They thought that language was preferable to the extent that I should say probably when, not if, the provisions are ever challenged in court, that would be more beneficial to have the statement of purpose phrased that way. So that brings us to the section that we began talking about with respect to firearm storage. You'll see that the first change is to the title of the new section. The proposed new section would read negligent firearm storage rather than secure firearm storage. Again, that's similar to the New Hampshire statute. And as Senator Brew mentioned already, one of the primary differences, if not the primary substantive difference here, is that there's no penalty any longer, and it's not unlawful for a person to store their firearms out of compliance with the requirements here. There must be some subsequent consequence, some negative result of the failure to
I just want to be clear that part of this problem part of this change comes because there's no real way of enforcing such a law that I'm aware of under the Constitution. Maybe other states have done it, but Senator Bohowski.
And maybe I'm remiss to bring this up, but I do wonder if it's sort of, if it could be constructed as sort of a secondary offense, like if someone gets called to a domestic violence situation and there's a child with a gun, it's then enforceable that that wasn't safely stored, but we wouldn't allow them to go into the home looking for that.
Well, and under the original language, that was my answer to people who talked about how would this be enforced. One is if the police are there for some other purpose. The other is if there's a subsequent crime and they investigate how they got the gun. But under this language, it's not an issue. So.
Child endangerment can always be.
I was wondering, that was going to be my follow-up question, is if a police officer shows up to a domestic violence situation and a child has a gun.
A 2-year-old has a gun, I think it's child endangerment. That's a current law. It's actually an application of a Reedsboro man. It happened in Massachusetts, but he was running away from a drunk driving with his 2-year-old in his arms, and somehow the 2-year-old ended up in a river and drowned, and he's being charged. One of the charges, child endangerment.
Yeah, I saw that. It was horrific.
Yeah, horrific. But I think, we forget we already have laws that. Okay.
Thank you.
Continue on.
Yeah, sure. And so much of the highlighting that you see here is restructuring rather than changing any substantive pieces of this offense. So the big picture substantive changes are the one you just mentioned, that the offense is no longer a crime, or it's not even prohibited, I should say, if there is no negative consequence to the improper storage, if it's just a straight failure to store in compliance with the requirements, that's not prohibited by this language. But other than that, it's just a restructuring, moving things around. For example, the penalties that you see at the bottom of page 4 and the top of page 5, those are just moved. So if you look at page 6, for example, lines 1 through 7, that's where the penalties are. It's not, those aren't changed. They just move from that page over to the substantive offense. And that reads better if you're phrasing it this way, and it's, I think is more accessible to the reader that way. So what's prohibited? Person who stores or keeps a loaded firearm. So they have to be the person who stores or keeps it within any premises that are under the person's custody or control. So they have to be the person who controls the premises, who knows or reasonably should know that a child or prohibited person is likely to gain access. So they have to have actual knowledge or constructive knowledge that a child or a person prohibited by law is likely to gain access. So it's not just possible, likely to gain access. And if all of those preconditions are met, even by itself, that still isn't unlawful. All of those preconditions have to be met, and one or two of the following, and you went through these draft, but just to reiterate that, subdivisions A and B, either under subdivision A, prohibited person or a child gains access to it and uses it in the commission of a crime or displays it in a threatening manner. That's the 1-year misdemeanor. And then top of page 5, if the child or prohibited person gains access and uses it to cause death or serious bodily injury. In that case is when it's the felony, the $5,000 5-year felony. So, and that's substantively the same as it was
Do you have a
before.
question about that, Senator?
I did, but I think I can just look at the old bill, because I thought before we only had the 5-year felony. Did we add this?
No, they were
I
both,
just missed it
yeah,
before.
they were
Okay,
both in.
thank you.
Sure.
We can change that.
Oh, of course. They, it's all policy.
This is just,
Yeah, I just missed the previous piece in the,
no, I think given some of the testimony this morning and other testimony and other emails I've had, we should probably consider B as whether or not something we want to do.
Consider B.
Yeah, the top of page 5. The felony,
Oh,
if death or serious bodily injury. To at least have a, that's one of the decision points that I've given Rebecca Turner's testimony.
I personally, I wouldn't want to get rid of the felony.
I mean,
I wouldn't want to eliminate.
wouldn't want to.
Right.
No, understood, but I think it's
Yeah,
a decision point that I've tried to identify. Given Rebecca Turner's testimony about constitutionality of creating that felony. Go ahead, Eric.
Sure. So you'll see lines 4 to 7 are struck. Again, that's just moved though into the, rather than being part of the substantive offense, sorry. It's moved into the, essentially, the exceptions. And the exceptions start on line 8. And so, even if all of these elements are met and the crime occurs, it's not necessarily going to be a crime if you fit into one of these exceptions. So what are the exceptions? Well, A, B, and C are the same as what you had in the previous bill. First one, very important one, as you were mentioning, Senator Sears, earlier during witness testimony. The firearm is carried by or within such close proximity that can be readily retrieved and used by the owner or another user. So you're not required to store it. And in fact, if the firearm is accessed in some way by a child or prohibited person, one of those bad consequences that we identified occurs, it's still not a crime if the person had it on their person to begin with. So if they had it for purposes of keeping it on themselves or within arm's reach, for example, if that's the case and somehow a child grabs it, then that wouldn't be a crime either.
Can I just want to, oh, okay, go ahead, Eric.
Yeah, sure.
Eddie.
Yeah,
Well, indeed, the person stores and keeps a firearm. This is Rogers, and again, another decision point. But separate from ammunition, I think if you, I always thought if you're storing the firearm in a safe, locked container, do other states have that?
some do and some don't. Some apply to
Did New
ammunition
Hampshire
somewhere.
require you to separate the ammunition?
That's
don't
a good
recall
question.
seeing-
Maybe not. Let's see. No,
No, we probably, it's a decision point, but I think it's something I missed when we were drafting, looking at New Hampshire.
And is the question here,
Well, if you're locking it up, and
Doesn't-
storing it safely,
Or,
why
so-
do you need to separate the ammunition?
right, where is if I'm,
Well, the idea is just to keep loaded weapons out of the circulation, even, I suppose, even if they're, in a gun lock or something like that. So belts and suspenders. So it's locked up and separate from
Well,
ammunition.
it's something I missed when I was trying to do New Hampshire, but we can, I highlighted it as another decision point to discuss, but anyway. so-
well, I'm glad you mentioned it for another reason, which is that I neglected to mention back on page 4, line 13, another difference, similar, and actually what New Hampshire does as well. So the negligent firearm storage offense only applies to loaded firearms. See that on line 13, person who stores or keeps a loaded firearm. So in other words, if the firearm is unloaded, then the crime wouldn't apply either. This is
Now,
a loaded firearm.
so in other words, let's say somebody leaves a gun with the ammunition next to it. And a child comes in, loads the gun and takes the gun and does something. Under this, there would be no penalty.
Yeah, I think that's right.
So that's something I'd like to,
No, the person who stores or keeps a loaded firearm within any premises that are under the person's custody or control knows the reason we should have known that a child or person gain access.
right, I mean, if they're negligent with their firearm and their ammunition,
I see.
and the child
Okay,
puts the two together, that should still be a crime.
okay.
well, and I think that's the question point for me, because if it is locked or in a trigger lock, I think it seems safe that it could be loaded, but how, is there a way to craft the language that sort of explicitly disallow, like, that they do need to be stored separately if they're not locked or do you know what I'm trying to say? Because that's what I was trying to get at with your
Yeah.
question, because I perfectly can understand why someone might use a trigger lock or lock, something in like when we were talking about the biometric locks. But to Senator Baruth's point, if the language isn't crafted really carefully, that would be perfectly allowable to just store them right next to each other unlocked.
Right,
I think what you could do, if the policy point, the sentence here said, so I think going forward, it's a decision point. But I think from a technical perspective, language wise, it'd be pretty easy to do if you want to go that route. You just strike the separate from ammunition piece in the storage, line 18, page 5, and you strike the word loaded from page 4. Then you'd have the situation where you wouldn't have to keep it unloaded if it were stored in the safe. It could be loaded in that situation. But the general requirement, the crime would apply whether the firearm was loaded or unloaded if you have reason to know that the child or prohibited person is going to gain access and actually uses it.
So that way sort of grants an exception to them needing to be stored separately if it is locked.
right.
Right?
Right, it would just, I think that's probably
And
something we
yeah, if we're going to do one, we should do the other.
can come back to next week. and
Yeah,
Join those two together.
yeah.
Just remember what you just said, Eric.
Right. I jotted it down. put a
Take
check
good
mark.
Okay, let's keep going here.
Sure.
I don't want to hold Mr. Anderson up. He's very busy.
So we just were talking about the exceptions essentially. We went through the one where you have the firearm on your person, also B and C, lines 13 and 15, you'll see that's also carried over from the previous version. If it's used in the result of an illegal entry or in an act of self-defense, then it's not a crime if the child or prohibited person gains access to the firearm. We just talked about the storage piece, that it's also not a crime if you store your firearm in the version right now, separate from ammunition and in a lock container equipped with tamper-resistant mechanical lock or other safety device. So that's another way that you can If your firearm is stored properly, then even if someone does gain access to it, it's not going to be a crime. Over on to page 6, lines 1 through 7 are the penalties. I mentioned that already. Those were struck, but they were just moved up to the front part of the bill. Lines 8 through 13, I think the committee, and this was also a recommendation of the Attorney General's office, the striking of the charging discretion. I think the committee had wanted to go in that
I think
direction.
we were all unanimous in that.
Right. Including the Attorney General.
Right. Yeah.
Next is
Because
the,
that already exists, right?
I mean,
Because
Yeah.
charging discretion already
yeah,
exists.
and it would lead to questions about why it isn't in other laws like shoplifting.
Got it, okay.
now we're moving into the warning section. Certain language is required to be provided as a warning at federal firearms licensees and places where firearms are sold. You'll see that the proposal on page 7 is to, and there were 2 paragraphs to this warning, essentially. Line 7 through 11 is not changed. That's about the risk of suicide in connection with firearms. So that remains the way it is. The second paragraph, lines 12 through 16, had said that, talking about how Vermont law requires safe storage, essentially. And some specifics around the storage requirements. And the last sentence being line 15, failure to securely store firearms as required by law may result in criminal prosecution. I think the committee thought there might have been some ambiguity there because of the fact that simply failing to store wasn't unlawful under the version that came over from the House. The language that you do see written there is one proposal, line 17 to 19. That's verbatim from the New Hampshire warning. So that's the warning that New Hampshire requires. It's important that the owner of a firearm seek firearm safety instructions from a certified firearms instructor and keep firearms secured from unauthorized use.
Can I ask Eric, this is a craft thing. I noticed that you deleted the headings.
Yes.
Is that just your preference? You don't like them?
Nope. It was just, I think Senator Sears was indicating that it was better without the prohibition.
No, understood on that one. I'm just wondering, like on information distribution.
Our editors are strict that if you use one somewhere, they all have to have
I see.
headings. So you either have them or you don't.
Got it.
No middle ground.
Well, then let's not.
Yes, exactly. I have to choose my battles there. The same reason that the bottom page 7, for example, line
Yeah.
21 definition struck for the same reason. And again, it's not, probably, I would say it's more common not to use them, but neither way is
Yeah.
correct.
Yeah, I'm just always looking for clarity in these things, so I like them,
I know,
but I know it's a style.
sure,
Um,
yeah.
So I see on page 8, we need to look at lock container, given the earlier discussion.
I don't think we do.
What about child?
We're just
The
talking,
definition doesn't change. It just, okay.
we just said that the weapon might not have to be.
It was suggested that we look at prohibited person. Just as Senator,
To one point that was brought up earlier, the term child, how does that match with the consistency in other statutes where we say juvenile, or we say minor, or, what do we say generally?
It varies, but it is consistent with the juvenile statute. Child.
To say child,
It's
okay.
used for person.
it could be under 16 too, could be 18, could be 16, whatever we decide. I'm not advocating for anything different, but under the way it's drafted, I would say it was 18 and under. But we could draft it at 16, we could,
Sure, it's a policy decision.
I like 18 and I like child for the reason that Eric mentioned, tracking with the juvenile statutes. But the other thing is it's mostly children who take these guns by accident and shoot themselves and others. And so I think saying that isn't a bad thing.
I'd want to keep it at 18 as well,
Yeah.
please.
no, that's fine with me, I'll just point you, I was just kind of answering that.
Yeah. Thank you.
We have had places where we made it 16, for example, for emancipation and things like that.
So now we're moving on to the ERPO section, the extreme risk protection orders. And you'll see one change that's made in several instances from the next 3 pages or so, page 9 to 11. And that was making clear that, and you remember, this has to do with the party substitution idea, that when the initial petition is filed by a family or household member, the party in interest is going to be substituted to be the state's attorney or the attorney general after that initial emergency petition is filed. So the proposal from the AG and the state's attorneys, and I think Judge Zone also, was that two things. A, be specific about which state's attorney it is. So that's why you see the language says the state's attorney of the county where the petition was filed, right? So whoever that initial petition was filed, it's clear that's the state's attorney that's going to get notice and is going to be substituted. And secondly, take the attorney general out. So the party who would be substituted would be the state's attorney of the county where the petition was filed.
So why is on line 8, page around 9,
Okay.
8A, state's attorney
Yeah, they can file an initial petition.
or the
This
office
is
of
on-
attorney general?
Yes, they
Okay.
still want to have that authority. This is only about who gets substituted if a family or household member is the one who files it initially. So that's one change you see in a number of different places. And the other one, I think Senator Sears referred to earlier, it's the top of page 11, lines 3 and 4. This is the idea that, so if the petition is filed by a family or household member, right now, an emergency petition is a preponderance of the evidence standard, more likely than not. The proposal here is that if it's filed by the state, by a family or household member, as opposed to the state's attorney or the AG, it would be a clear and convincing standard, which is the same standard that's used for the final order, the 6-month order that comes up, after 14 days.
My reasoning was that this is an ex parte hearing.
Right.
It's a hearing where the defendant doesn't get an opportunity to challenge. And under the current law, red flag law, the state's attorney hears from a family member, a doctor, police, they've investigated, they have reason to go forward. And to me, a family member could be extremely upset, whatever, but it may not be at that point for that individual. And I think, given the on-call judge at 10 p.m., the ability to hear it is clear and convincing rather than the corners of the evidence is a safeguard for that person. It doesn't prevent the family member from still going to the police, still going to the court. But if they choose to go directly, the state's attorney, but if they choose to directly go to the on-call judge, I just feel strongly that it needs to be clear and convincing evidence. But certainly the committee's choice and it's another decision point.
Right. So that's pretty much it. There's a severability piece
Yeah,
added
maybe
in
you should
section
go
8.
through that, Eric.
Yeah, and that's just, again, it's not technically necessary because we have a general severability provision in the Vermont statutes. But I think the committee felt in this particular instance, because of the very high likelihood, if not certainty, that this legislation is going to be challenged in court, the committee wanted to be extra clear that in this particular instance, the provisions are all separate. So if the waiting period, for example, or the safe storage provision is found unconstitutional, that wouldn't affect the ERCO provision or whatever other provisions there are in the bill. And that's the idea of the severability provision. I mentioned the title change already, you see at the very end, which also has a typo. And those are the
You
proposed.
have until next week to fix all these problems.
I think that should be enough time.
We're gonna take up with H230 again next Tuesday or Wednesday, depending upon what Senator Sheem and I and Peggy work out for timing. So it's out there and in internet land, and we'll see what we get. See now, email saying, don't weaken. Email saying, still doesn't satisfy me.
The house.
I've come to realize on some of these controversial issues, you only know you're successful when nobody's happy.
Right.
Exactly.
We'll see. Again, I didn't touch the waiting period. I leave that to all of you who might support the waiting period. Oh, and I do intend to vote separately by section on the bill when we get to actual voting.
Mhm.
There may be sections that certain members support and sections that they don't. Wherever you get 3-2, it's in the bill. If you don't get 3-2, it's not in the bill. So we're gonna go on to, I thought it was sports betting, but it's now sports wagering. Tucker, you join us. There's some crimes in the bill, and that's what I wanted us to go over.
I did want to ask one question there, comes from, just before we take off. It's a quick one. It's on page 1. The Rand Corporation was deleted, where it
Yeah.
says 44% of the Vermont households. How did they come about this information?
The Department of Health did it, I don't know.
But do you know how they get this information, or seems kind of
Probably
random?
asked them.
They poll 100 people and they come up with 40
Might have been.
people that said yes? I don't know. Okay, anyways.
I think the Department of Health, I think actually the Department of Health did some surveys. I think they're ongoing. I think that.
Every couple of years.
Yeah, I think they've been doing sure. I don't know for sure though. It's a good question, Bob. I don't know for sure. They must be accurate.
Oh, it has to be.
Tucker, please.
Hey, good morning, Tucker Anderson, Legislative Counsel. Does the committee have the official version or the unofficial version? I want to make sure that I'm calling out the right unofficial, the Zorro marked edition.
Where did I lose that, baby? I've still got 828, the governor already signed.
Is it H127?
H127.
Pass
Oh,
by.
I don't think
I have page
Have it.
16 through 30.
Yeah, I just printed out the pages that says.
Oh,
here's the-
Oh, thank you.
I've got
We're
multiple.
starting on
Do you have,
page
does everything have
16.
it?
Yeah.
I don't
start
think
with
I
crimes
do.
and penalties.
You sure? Should have been in there.
I've got H494, H89, 2 copies of H230, and that's it. And- Oh, wait, there it is. Thank you. I knew I did have it and I lost
Crimes
it.
and penalties.
Everybody have it?
I do have it, Peggy.
Okay.
I should have known better.
Okay, so you have in front of you H127. I'll point out the crimes and penalties provision to give you some background about the general architecture of the sports wagering market that you're dealing with here. The proposal in H127 is to allow the Department of Liquor and Lottery the sole authority to offer a sports book in the state of Vermont, mobile wagering only, and they will contract out the privilege to offer sports wagering in the state to 2 to 6 sports wagering operators. You can think of these as kind of the licensees. They're really agents under this contract formula. And these would be companies that you're probably already familiar with that offer mobile sports wagering. So that's the privilege operated through contract. That market would be the sole legal market in the state for sports wagering. And currently in Vermont, wagering is a criminal activity. In Title 13 and multiple provisions, there are existing criminal penalties for bookmaking, for offering certain types of wagers, and for offering gambling that is akin to wagering, but might be a contest or a lottery. And there's even special criminal penalties for exceptions to those criminal penalties. Nonprofits are allowed to run things like casino nights and to offer certain types of contests and certain types of limited wagering activities. But if any of the constraints around those nonprofit activities are violated, there's different criminal provisions that apply to those actors. So if all of that is background, H127 has an interesting formula built into it as it has come out of the House that I flagged for Senate Economic Development and that they then have flagged for you all to review. there are parallel proceedings that can be carried out specifically for the operators that might violate the provisions of this chapter. The first is that if an operator violates the chapter, the procedures that are adopted by the Board of Liquor and Lottery, or any of the contract provisions, the Department of Liquor and Lottery can bring a complaint to the Board of Liquor and Lottery, and the board can impose monetary penalties or suspend the contract. Simultaneously, you have in section 1325, which is on page 16, a crimes and penalties provision. Subsection A deals with the universe of people who are not allowed to offer sports wagering. This is any person who is not permitted to conduct sports wagering that operates, conducts, or exposes sports wagering for play or accepts a bet or wager.
Are corporations persons?
Yes.
too, Under this,
Corporations
So,
can be
how are you
subject to
gonna
criminal
put
penalties.
DraftKings in jail for 6 months?
You likely would not
That's the
when
problem.
you're dealing with.
The first problem I see with this is we're creating up maybe the principal owners.
I was just going to say that there are criminal penalties that apply to corporations in certain
I
contexts.
just
You can
can't wait
make
to
a,
put Jonathan.
for
Kraft.
example, environmental crimes, right?
Right,
You can go after the corporation and you can likely, if you're capable of piercing that entity, go
I
after.
want to finish my comment because we are on YouTube. I can't wait to see the state of Vermont attempt to put Jonathan Kraft in prison for 6 months. I didn't mean I can't wait for Jonathan Kraft to be in prison. I love the Patriots.
Okay.
Make sure that's on the
Who's
record.
Jonathan Kraft?
Well, I just wanted to clarify because I realized they
Robert
just said
Kraft.
something.
Okay, now I know what you're
Yes.
talking
Well, Jonathan is DraftKings.
about. Oh, okay.
Now I know more. Okay. There are 3 staggered penalty provisions here that can be applied to someone who offers sports wagering, but is not licensed, or in this case, not contracted to be an agent of the state. First violation, $25,000, or not more than 6 months in prison, or both. Second violation, $75,000 or not more than 1 year, or both. And for a third, $150,000 or not more than 2 years, or both. For reference, the highest penalty that is applied in Title 13 currently would be $10,000 or 1 year in prison. So these are.
Why are these so high?
They were
Was that
raised.
your question? I'm sorry.
That was part of it, yeah.
Why are they so high?
They were raised through a floor amendment by the House on second reading. And that was based on research done by members about what the average penalty is in the legal sports wagering states.
Senator Shin.
I mean, at first I have hesitations for jail time for non-violent crimes. That's a conversation for later on in this, but so, I mean, if somebody, just a random guy is trying to run a sports betting event in his basement and he's unauthorized to do it, they could face a $25,000 fine is what I'm picking up from this.
Yes.
Okay.
And currently, right now, if a person is doing that and a state's attorney wants to bring a citation against an individual who's offering a book out of their basement, the penalty would be $250 or 6 months, not more than 6 months in prison.
And by the way, it's or in prison, not in,
Correct. Or both.
which
And
is
just-
unusual.
Yeah, I just think there should be some sort of delineation between the random guy in his basement versus DraftKings.
Yeah.
You know, there's a lot of.
Yeah, I agree too, that the random guy in his basement versus, a huge corporation should be differentiated, because if I'm understanding currently, this is completely illegal. And if I'm a random person in my basement, I would be subject to a $250 fine. And when we are legalizing this, I would now be subject to a $25,000 fine
In 6 months,
and jail time.
or jail.
Or 6 months.
Yeah, that's an odd way to write it, but
Now, there are here overlapping criminal provisions because you have this, but the Title 13 provisions related to bookmaking aren't repealed. So a state's attorney, if this passes, would
You get
have
two
the
choices.
option of choosing whether it's going to be the $250 bookmaking fine or the $25,000 fine
was the
here.
intent, and I don't remember, I was on the sports betting committee.
Yes,
I don't remember discussion of criminal penalties there.
it did not come up in the sports betting study committee. However, Senator Sears, I think if you go listen to the House Government Operations and Military Affairs Committee meetings about the criminal provisions, that they do reference something that you expressly brought up in the sports betting study committee, which was offshore illegal
Right.
actors. And that is primarily what the House referenced on the floor when discussing this.
So can we make clear that what group we're referencing here?
Potentially.
That was the group, I was talking at that time, and thank you for refreshing my memory, about groups from Nigeria who actually operate websites which look like they're out of Las Vegas.
I will check in with Eric and see whether this can specify the parties that this could be applied to.
Well, I think, I know I would be more comfortable with these penalties, and I suspect the majority of the committee might be more comfortable if they were directed at the actual offshore betting operations that were trying to shut down the illegal market by having this legal market.
Is it, I just, one question, Tara, is this something that was drafted here in its entity, or did they pull this from other states that allow?
This was drafted specifically for this bill, and it mirrors some of the average penalty amounts that you might see, for example, in Pennsylvania and New Jersey.
Given, if it's directed at the offshore, or perhaps the term foreign would be the better term. I think foreign gets you to non-Vermont operations, not the guy in his basement trying to, because that's already illegal under Title 13. I would be more comfortable with the penalty section.
The another thing to note about the average, we'll say national now that there are so many states, national average for these penalties is that many of those states are casino states where perhaps the number of licenses that are issued are limited. And you might have, for example, an in-state casino or similar higher class licensee that doesn't have the privilege to offer sports wagering who would be subject to a penalty that high.
Well, and then,
Something to balance.
What we discussed in the committee, we'll be lucky to have, we're allowing up to 6, but it probably is likely to be a maximum 2 or 3.
Could we, and it probably later on in the bill covers this, could we at least look at the possibility of limiting this to within the United States, getting away from the DraftKings, or maybe across the, I mean, how would we enforce this if they're across the pond here, or whatever else, so to speak, or any licensed entity within a state that's already licensed? I mean,
If this is trying to draw on civil procedure review, but I mean, if there's a corporation outside of our state that's intentionally reaching into our state to get people involved in their sports betting, there could be jurisdiction over that corporation, even if they are incorporated or operating somewhere else or headquartered somewhere else.
right, but I'm saying within the United States versus across the pond, so to speak. You use DraftKings, you said Africa or whatever you said.
Yeah. I'm not sure I follow.
Get an extradition order against the corporation.
There you go. Yeah, we'll bring that person in, that John Kraft, whatever it is.
There's another subsection here, and it applies to the operators themselves. These are the legal actors.
Want to go there?
This is where the tension is. It's in subsection B. An operator who violates the provisions, there's no prison sentences here.
What pages?
We're still in section 1325 on page 16. It's the exact same monetary amounts, but these are strictly fines. There's no prison sentence attached, and these apply to the operators. The Office of Professional Regulation has a similar model where OPR itself can bring fines and potentially criminal complaints, or the Attorney General or the state's attorney, upon referral by OPR, can pursue a criminal fine for a license violation. So there is some precedent for having two different venues for bringing these sorts of penalties. But I did want to flag it because outside of the licensed professions in the state, this is somewhat unusual.
Okay. We're